Amanda?
Yeah, I'm here.
Okay. Should I start allowing people to join the meeting, or should I wait until closer to 11 and just allow everybody?
Yeah, let's wait till closer to 11.
Okay. Thank you.
Okay, thanks.
Good morning, everyone. We'll get started here in about 3 minutes. Thanks for joining today. Well, again, good morning. It's good to see everyone. I'd like to call this meeting of the Nevada Common Interest Communities Task Force to order at 11 o'clock here on Wednesday, February 25th. Letty, I'll turn it over to you for a roll call.
Good morning, Letty Chavez for the record. Dr. Chris Sanchez,
Here.
Donna Zanetti,
Here.
Michael Buckley. Michael Buckley. Jason Horn.
Here. And Michael Buckley's here too. He's been trying to get his mic off, but he got it.
Thank you.
Thank you. Assembly Member Heidi Kasama.
I am here. I see it says my husband's name, Peter Kasama, I'm on his computer, but it's really me, Heidi Kasama.
Thank you. Good morning. Thank you. Garrett Gordon. Garrett Gordon. Doug Flowers.
Present.
David Barron.
Here.
Mark Leone.
Here.
Phil Sue.
Here.
Crystal Keegan Park. I'm
Here.
sorry. Crystal Park
Well,
Keegan.
she's also
Here.
promised me to become a manager for so long.
Sonia
and
Merriweather.
nothing happened.
Here.
So Nani's gonna give me some
Shara,
talking points and maybe give her a
Chandra?
spot bonus,
Yeah.
but.
Can we have everybody mute,
But
please?
she came over, like, Penny was only making low 40s. Sonia's making 57.
Sorry about that, Letty. I think the last one I caught was Crystal.
Okay, I'm sorry about that. I called Sonia, Merriweather, and Sharath Chandra, and we do have a quorum.
Great. Thank you for that. Moving on to agenda item 2, public comments. Turn it over to Amanda Flacchini.
Good morning, everyone. Amanda Flacchini for the record. Just a few notes on public comment. No action may be taken upon a matter raised under this item of the agenda until the matter itself has been specifically included on an agenda item upon which action may be taken. Comments will be limited to 3 minutes. If you are making public comment via phone, please dial 775-321 6111. The phone conference ID number is 588-856-862#. And I will hand it back over to Director Sanchez. And as we do public comment, I will have a timer up for 3 minutes that I'll share on the screen so everyone knows the time frame.
Do we have anybody that wishes to speak during public comment? Please speak up if you do. We'll kind of take a list here. I cannot see everybody, so if you have a hand up on Teams, that'd be the best way to do it. All right, I see Mike Kosar. Please go ahead. I think you're
believe
muted.
you're muted. Looks like the speaker hasn't, or there's something wrong with the microphone.
Mike, while you're working on your microphone, is there anybody else that has public comment? We can return back to Mr. Kosar.
Can you hear me now?
Yep.
Yes.
Okay. Yep.
All right.
Floor is yours.
All right, thanks very much. Sorry for the confusion there. As been noted here, my name is Mike Kosar, and I provided written comments on several items on today's agenda, and I understand they've been made available to you, so thanks to Charisse for making that happen. Before addressing specific items, however, I want to acknowledge a broader institutional context suggested by today's agenda. Many of the issues before you are the types of questions Nevada law already provides mechanisms to address through regulatory classifications and administrative review. Those mechanisms reside primarily with the division under existing statutory authority. I recognize that discussions on those underlying processes not on today's agenda, and I have asked that they be put on the agenda in the future. But I mention it only as a context because the fact that those long-standing issues are now before this body highlights the importance of your work and the potential reforms. The issues before you fall into two different categories and distinguish between the matters. The 4 items listed under Agenda 5, such as the definition of meeting, that's 5.1, and how allegations of violation should be handled, and that's 5.3, reflect long-standing statutory ambiguity. Nevada law regulates meetings extensively, but never defines the term itself. Questions like these would ordinarily be clarified through regulatory interpretations as they arise. Their continued presence shows why the task force review is necessary today, not just to resolve the meeting ambiguity issue, but why it's before you. ADR, however, is different. And I have provided you my comments there. ADR is not an ambiguity problem. It is a question of delivery results. Lawmakers have long sought a low-cost and efficient way to get neutral and trusted determination before owners and before litigation. The statute framework is clear. The problem is that the process does not reliably work, okay? And I don't believe that switching, and I oppose what appears to be a proposal, and that is to switch to the arbitration method when the referee program exists out there today and should be used and is much simpler and cleaner. Okay, the referee model provides a decision-making process that is faster. Okay, the problem that referee lacked authority is that the access to the referee program depends on mutual agreement, allowing one party to veto the most effective solution mechanism. So my time is up, and I appreciate that. I look forward to the discussions of ADR and hope this task force is up to the task. Thank you very much.
Thank you, Mr. Kosar. Do we have any other public comment? Please speak up if we do. I cannot see everybody on the screen. It looks like, let's see here, sorry.
Solomon Bradley, you can unmute yourself and your time will start now.
Hello, Solomon Bradley. I'm a former board member at Sky Las Vegas HOA, which is a 45-story building on the Strip with an average HOA fee now of $1,100 a month. We get a lot of amenities for that, but it's still too high, and there's no board is perfect by any means, including ours. I will echo the comments of Mr. Kozar. I fully support the referee program. If you can put teeth into it to kind of steer both parties towards that, I think that would be great. The ADR program, I've been through that before with my board, and it frankly just wastes money. It wastes the taxpayers' money. It wastes the homeowners' money. People go through the motions to negotiate in good faith with my air quotes, but nothing rarely occurs because of it. Both sides dig in, and lawyers are the winners. They go home smiling, which it seems to be in many cases. So one thing to alert you to, at least one judge in justice court, her name is Judge Jessica Goody, has now recognized that there are big problems in HOAs and big disputes, and homeowners rarely get any fair justice through NRED or through the ombudsman. And that could be perception, but I'm here to tell you, as you know, that's reality as well. So she is a unique judge that has started to allow homeowners to sue their HOA in justice court without going through formal ADR process. And when the attorneys show up on behalf of the homeowners association, go, wait a minute, we have to go through mediation first or alternative dispute resolution. She looks at them and goes, all right, there's a conference room in the back of my courtroom. You got 30 minutes, discuss it. But I'm hearing this case today. I applaud that judge for being an elected judge, answering directly to her voters to serve the people by solving these disputes in her courtroom. And I hope it heads that way. But this committee could take a leadership role and show that you have a program that doesn't just work in name only, but really works. And I back up the referee program on that. Thank you.
Thank you, Mr. Bradley. Do we have any other comments? Okay. Letty or Amanda, do we have any comments on the phone?
Not that I can see. If anyone's on the phone joining, and you have a public comment, you're welcome to share now or unmute yourself. Otherwise, we will move on to the next agenda item.
Okay, and seeing none, I just want to make reference on the record that we did receive comments from William Lovgren, Paul De La Cruz, and Mike Kosar, as mentioned by Mr. Kosar during his comments, and those are in the packet. If there are any constituents that are listening and have sent materials in, you can let us know that in the chat, and then we can certainly include those as follow-up to our members of the task force. With that, we'll close out agenda item number 2 and move on to agenda item 3, and that's our first presentation. And I'll turn it over to Sharath.
Good morning. Thank you, Director. So the first item is a report, and I believe Michael and Member Buckley and Sonia Merriweather will present on this. So essentially, sometime in August of 25, a policy researcher from the Rand School of Public Policy reached out to the division to participate in a study, and that was primarily done, I believe, for the Hawaii Legislative Reform Bureau was commissioning a study. And so that part of that, Michael and Sonia graciously participated in. And so, and then there was a report that came out recently based on all of those conversations with different states. And so I'll turn it over to Michael and Sonia to kind of go over what their thoughts were and kind of briefly about the report. And also, I think we have a link for the report, if not the entire report, available for review. Thank you.
I'm going to start first. Good morning. In your packet, you were provided with a copy of the RAN project, which is a 5-state approach to condominium law, which is a comparative report that examined how California, Delaware, Florida, Massachusetts, Nevada regulate and govern common interest communities. On September the 16th, Micah Buckley and I were interviewed for this report, and we're going to provide you with an overview of its findings. The Hawaii Legislative Bureau, Reference Bureau, commissioned a study to improve condominium governance and dispute resolution. The study reviewed regulations and best practices from various states to identify ways to strengthen consumer protection and the management of condominium associations. It focused on 6 key areas: ombudsman's processes, government relations and enforcement, alternative dispute resolution, owners' access to documents, point of sale education requirements, and condominium association management. I will be providing a summary of these 6 key areas, and Michael will provide insight into the strengths and weaknesses of Nevada and best practices for all states. The study reached out to more than 120 stakeholders across 5 states to gather perspectives from both government and private sector participants. In the first section, it addressed state regulations and enforcement. This report indicated that states varied widely. Florida and Nevada had a comprehensive regulatory framework with clear enforcement authority, subpoena power, and multiple complaint pathways. These systems benefit from stable funding and defined administrative authority. Whereas California had extensive statutory requirements, but lacked centralized enforcement capacity. Delaware's dual statutory process creates confusion, and Massachusetts offered significant association autonomy, but provided no meaningful enforcement or penalty mechanism. The key takeaway was effective oversight requires clearly defined authority, transparent complaint processes, equitable treatment of owners and associations, and sustainable funding. The second section was the Condominium Ombudsman's Office. The active offices were in Delaware, Florida, and Nevada. California had 3 unsuccessful bills to establish an ombudsman program, but currently they have none. And Massachusetts proposed 2 bills, and they're currently established an office within the AG's office, and it's currently under review. The Ombudsman's offices serve as neutral resources for education, education monitoring, and dispute facilitation. Where properly funded and clearly mandated, they enhance transparency and trust. Moving on to the third section was the alternative dispute resolution section. And as we know, disputes between homeowners and associations will happen. States such as California, Florida, and Nevada required mandatory ADR, which reduces court burdens and often resolve disputes more quickly and affordable. Delaware offered voluntary ADR, but faces resource constraints. Massachusetts has no dedicated ADR program, and they rely on private arbitration or the courts. Looking at the owner access to association documents, comprehensive, we had California, Delaware, Florida, and Nevada. With basic rights, you had Massachusetts. All 5 states granted owners access to important financial and governance records. Florida and Nevada stood out for requiring online portals and providing enforcement mechanisms. California and Delaware had broad access laws, but weaker enforcement. And Massachusetts provided limited rights without penalties for non-compliance. Moving on to the disclosure and education at the point of sale. Most states require disclosure of governing documents, budgets, reserve studies, and insurance information. Nevada uniquely requires a plain language educational statement to help buyers understand their responsibilities. Massachusetts has no requirement. States with disclosure requirements have cancellation periods ranging from 3 to 15 days. Interviewers noted that while disclosure is valuable, documents are often dense and unread. Looking at condominium management licensing, the management licensing varied significantly. Florida and Nevada required comprehensive licensing. California offers an optional certification, and Delaware and Massachusetts has no requirement. Licensing ensures managers possess the specialized legal and financial knowledge necessary for complex communities. However, requirements must balance consumer protection with workforce accessibility, offering an affordable education, reciprocity, and ongoing training for managers and volunteer boards. Some of the challenges that were across all of the states, challenges such as volunteer board capacity, where you have a high turnover and limited training, weakened governance effectiveness, affordable housing conflicts, rental and density restrictions sometimes clashed with broader housing policy goals, insurance crisis. Rising premiums threaten associations' budgets and aging infrastructures. Deferred maintenance, highlighted nationally after the Champaign Towers collapse, underscores the need for stronger reserve funding and oversight. The RAND report shows that condominium oversight ranges from minimum government involvement to comprehensive regulatory systems, and that effective models share common elements such as clear enforcement authority, sustainable funding, accessible dispute resolution, transparent document access, meaningful buyer education, and competent, well-trained management. Thank you. And at this point, I'll turn it over to Michael.
Thank you, Sonia. I'll start. I prepared an outline which I will share when when we're done with the meeting. One of the things that makes perfect sense is that the reason Florida and Nevada have the most comprehensive regulatory structure is that Florida, 43.35% of the population lives in associations. Nevada, it's 41.33%. The next closest is California with 36, Massachusetts 24, Delaware with 10. The RAND study focused on condominiums, but as you know, in Nevada, a planned community where the HOA owns the property rather than the unit owners has the same regulatory structure. So I think what the takeaways are from the condominium analysis also apply to Nevada in our planned communities. So one of the things that what RAND did, they looked at the regulations, they read articles, government reports, practitioner sources, and they interviewed legislators, regulators, public officials, attorneys, and legal specialists, CAI chapter and community leaders, association board members, mediators, arbitrators, homeowner advocates, academics, and researchers. So, and one of the things I think Sonia mentioned that Nevada stood out as one of the top states. It's a great compliment to our structure. So as far as the strength and weaknesses of Nevada's approach and governance, the strength they thought was diversion of disputes from litigation to administrative or ADR channels, which reduces the costs and escalation, robustness in addressing a wide variety of existing and emerging issues, and a clear pathway. The weaknesses they cited were the length of time it takes to resolve disputes. Some people said a weakness was a short statute of limitations, which is 1 year, which I'm not sure that we would all agree with that. As far as the ombudsman goes, they like the ombudsman. Again, educational efforts, first point of contact, early intervention were all pluses for Nevada. The weaknesses were staff turnover. So apparently you get valuable experience working for the ombudsman, then you can go out in the private sector and get a more high-paying job. So that's a problem with the staff in the division. And also the frequent engagement with the staff with conflict, and you can get burnout pretty quickly. So there was a weakness cited of staffing levels limit educational services across Nevada's geographical dispersed communities. And the biggest weakness in any of these programs is budget constraints and funding, although Nevada was complemented on the funding with the door-to-door funding. As far as the ADR, the strengths they thought were the subsidies and cost caps, which makes ADR more accessible, and mediation must be completed within 60 days, and the diverse professional backgrounds of mediators. Weaknesses were the rising costs have outpaced funding. The fee and subsidy structures have been unchanged for 10 years. A limited mediator availability, particularly in Las Vegas, and ADR lacks enforcement strength, allowing parties to prolong the disputes to the disadvantage of persons with fewer resources. As far as access to governing documents, Sonia pointed out the strength in Nevada was online portal, and they recommended that Nevada should have, it only applies to if you have 150 units. They suggest that it really should be, the best practices would be for every association to have online portal, and for the state to make that provide subsidies or technological help to get smaller associations having online portals. Also, as far as owner access to governing documents, the weaknesses also in Nevada were cited as is underused by homeowners, the lack of awareness of the right to these documents, and owners don't engage until a problem comes up. Also, concerns about associations creating bureaucratic hurdles when people are seeking documents, but abuse from both sides. Again, this is Nevada, owners harassing associations, boards withholding information. And they point out, and I think this is a big issue that I think our task force needs to think about. Access does not guarantee understanding of what those documents are, and there's a lot of misinterpretation, and also outdated documents that conflict with newer state laws. Owner education at the point of sale. They like, as Sonia said, the plain language disclosure that's required by statute. The weaknesses they cited were if the effectiveness of owner education at the point of sale. The homeowner lacks, and it's really, I don't think this is Nevada, but it's basically you have this big stack of documents and you don't read them and you don't really understand them. And there's no strong mechanism to confirm that people know what they're getting into. As far as the management licensing, it's basically, they said it's a cost benefit, and I don't think I will go into it because we do have licensing, and I think that once you make that decision, it goes on from there. Again, what Sonia mentioned, these were identified as emerging issues, and they were the challenges of volunteer governance. Florida has mandatory director training. 4 hours are required. There's discussion or question whether that deters people from participating or helps. Affordable housing initiatives. And I mentioned this, and this may come up in the future, and that is, you may remember that there's a new law that was passed that said all of the local zoning laws have to permit ADUs. But when the sponsor of the bill was asked what happens if the CCNRs prohibit, putting extra buildings on your lot, or there's other restrictions that prohibit ADUs, the CCNRs prevail. And I'll mention that when I was researching that California has laws that make any restriction on ADUs void, and so as to permit ADUs. And so we're not there yet, but we'll see what happens with that. And then the insurance, that's a big issue. It's probably, not so much a CIC issue, but an overall issue. And then the aging condominiums. And Florida, after the big thing in Florida after the condominium collapse was a bill that requires a milestone inspection after 30 years and inspections every 10 years after that. So that's certainly something that, we don't have the same weather issues that Florida does, but we do have old buildings, and that's at some point could be a problem. And again, I'll circulate my outline. Thank you. Happy to answer any questions.
Thank you both for the summary. Now we have time for discussion. Are there any questions for the Ombudsman and Mr. Buckley? Task force members? Any comments?
Doctor, I would like to just ask Mr. Buckley, based on the report and for that matter, the Ombudsman as well, of the findings of the report, realistically, and for realistic application to the way that we operate here in Nevada, what would be some of the, I guess, I don't want to use the word low-hanging fruit, but what would be some easily achievable solutions or recommendations from the report that we could apply here in Nevada? I'm sure there's others that would be require more work, but what would be, what can we glean or take away from this as something that we could reasonably apply in the near future?
One of the things that they talked about, and it was a complaint in Nevada, was that maybe the Ombudsman should attend meetings at which there is an election. But then that really goes into, does the Ombudsman have the staffing to do something like that? So I think that was one thing that came out. Another, they talk a lot about the plain language, and as I've been thinking more about the task force, we're kind of more of a policy body than we're going to write the laws. But certainly an emphasis on more plain language disclosures. The Attorney General's warning that has to go out with the packet was really complimented. It's simple. So maybe one of the things, low-hanging fruit, would be maybe we should have a disclosure form that goes into some of the basic restrictions or issues that you get into when you join live in an association. Right now the disclosure talks about you can be foreclosed and lose your home, but there's a lot of other strings. Like we just saw the point that the public comment came today. Are there parking restrictions? Are there, if you want to change something in your house, do you have to go through a process, and what is that process? And so those kind of things, I think those could be, it would take some work to do it, but I think those are kind of easy things.
Thank you.
And I'm going to agree with Michael. The election was one of the biggest things because Nevada was so ahead of the other states. One of the focuses was elections because they do have a state that goes in, and that's part of the duties for that office is to perform elections and go to elections. One of the things that I know that we can do here in Nevada is Again, the focus is on always education and just the awareness of the office prior to a unit owner needing the services of this office. So that's one of the things that we are striving to do better, to have the public have better knowledge and awareness of the office.
Just to follow up on what Sonia was mentioning, and it may be a little bit different, but Director Sanchez, you may be aware of this because I was doing some research on mobile homes, and the housing division has a great web page on some of the things you should ask or know when you're moving into a mobile home park. There's disclosures, and there's a web page that has helpful information for anybody who is going to move in there. So it's maybe something the real estate division could follow.
Yeah, I appreciate that suggestion. It's a good example, and we're also, since we're talking about adjacent industries, so to speak, we're also looking at insurance and the disclosures that one has with insurance, and so trying to simplify everything into plain language across the different industries that we touch at Business and Industry is very much something top of mind. So I appreciate that reference, and it's something that we are looking at pretty intently. Assemblywoman Kasama?
Thank you.
This is Garrett Gordon.
Director.
I have a question. Oh, go ahead.
I just wanted to add with some of the comments. I'm in real estate. I also have a property management company, and I also own property in HOAs. So I get to see the whole gambit of all of this. And to the one comment about it'd be great to have people there for elections. I can tell you that most of the HOA meetings are at evenings. They have them at evenings, so when people are home from work, they can go to them. So it's a nice idea, but I think it would be impractical to have state employees or from the ombudsman office to be expected to go a lot of these in the evenings. So I just think that would be a difficult starter, so to speak. As far as the disclosures go, as many of you know, we have required what we call a resale package, which is a requirement from the real estate division anytime you buy a home. But if you print out these packages, some of them are like an inch thick. And to Michael's point, people sign off on it because they're excited to buy the house. And buried in there is the reserve study, is the latest minutes, is the latest financial statements, is the rules and regulations. And I can't even believe I'm going to say this because I hate to add another form, but maybe if you had a one pager, because people were talking about simplicity, that, for example, maybe a one line that said, the reserve study says you need this in your account. This is what the current association has. So it's funded at 15% or 20%. And then the buyer initials next to it. So for example, in this one community where I own a townhome, they did the Turk conversion. And so there was an assessment for $4,000, and people are buying townhomes in there for $250,000 or $300,000. They don't have $4,000 for the assessment for the condo conversion. And there was a big uproar that I would never have bought in this community if I had known that. And so they were afforded the documents to look at, but they didn't. And so, so my one example was just, a one pager talking about maybe, really bold, here's the percentage funded, which means you could have assessments. And do you have something that says there are currently lawsuits, yes or no, initial next to it, rules and regs, maybe some big highlights, make sure you read it, but this community does not allow dogs or does not allow parking on the, some kind of major highlights where I've sold in communities where you're not allowed to park in your own driveway, and that's became a huge issue after they bought. And so, maybe some of the pain points that we see are common for buyers that they've missed, even though they had these opportunities to look at it. But it is overwhelming. It's overwhelming in the buying process. They have loans this thick, all this information from HOAs. But like I said, I can't believe I'm recommending another form, but maybe like a one pager where people just initial next to really important bullet point items. Might be a thought to help with the education process for the buyer.
Thank you for that. I think we had a comment from Mr. Gordon.
I did. Hi, everyone. Garrett Gordon here. Sorry I'm not on Teams. I had a problem with the link, but I was able to call in. Michael Buckley, hello. Good to hear from you.
Hey, Garrett.
So we're back at it, huh? So CAI has a draft bill for everyone on the call who doesn't know CAI, the Community Association Institute. They have some language that the national CAI put together that have been going to different states. You mentioned the Surfside tragedy in regards to that, Florida beachfront condominium that collapsed. And really the goal with the language is to, ensure inspections, pre-construction, construction, post-construction, making sure there's adequate reserves for any repairs in response to those inspections, and some other language that certainly tries to prevent a catastrophe like that from happening again. I know you mentioned you were looking into it. Would it be helpful if I sent you this language of what CI National is proposing in other states to maybe we take a look at and see if it works for Nevada?
Makes sense for me. I think, one of the things, Garrett, as you know, is that it would be great to have a bill that was already vetted by stakeholders so that it has a smoother sailing when it gets into the legislature.
And I can say in regards to this bill, CAI board members are talking with the engineering board, licensing groups to make sure engineers are comfortable with this, and then going down the normal course of business with the realtors, the builders, the plaintiffs bar, all those folks. So I didn't know if that's something that we or the task force should look at as well, or we'll continue that path with all the stakeholders. But I can say that those conversations with stakeholders are happening, and language has already been amended in response to those conversations from last session.
This is Chris. I think it's a good idea if we can provide that to the full task force, and we'll get it in the next packet for everybody to review here between meetings. Was there anything else that you had, Mr. Gordon?
No, that's it. Thanks for the opportunity.
Thank you. Were there any other comments from the task force? The one thing I'll just comment in before we go to the next agenda item is the staffing issue. This is something that we are acutely aware of at Business and Industry. I wish that I could say that the Ombudsman's office was the only one where other state agencies poach or a private sector poaches, but that's not the case. We have a lot of staff positions available because folks get trained in the state and move on to better jobs, and not necessarily better, but better paying. And we actually help facilitate that. We don't want to hold anybody back. We want to get them trained and help them take care of their families. And so we embrace their upward mobility and see that kind of as a positive thing. However, we need to be competitive with the communities around us in terms of the cities and the counties, and to some extent, at least in the ballpark, with the private sector, and we're not. And so we have an opportunity, I think, to look at on the whole, again, kind of the comp and class structure for the state, and some changes that need to be made in some very specific instances across not only Business and Industry, but some of our other agencies where we're having a really hard time staffing up. So I'm just bringing that forward for the task force to be aware of, because this will be something that we're no doubt going to be talking about in the next session. So if there's no other comments on agenda item 3, just confirming that, please speak up now. Okay, seeing none, we'll move on to agenda item 4, presentation, discussion, and possible action item. And I'll turn it back over to Administrator Sharath.
Thank you, Director. So I want to be mindful of the time too, and kind of everyone's, other commitments. So we'll kind of, and we want to leave enough time for discussion on the rest of the items too. So I think we've been talking about this matter, and the ADR process. And so Sonia had put together a really good document that's just part of your attachments. So I originally wanted her to go over this, but really I think it's very, it's a comparison document and also a quick brief summary of the ADR program and our role in the ADR program. And so I'll just kind of reference you to that document. And really our goal at the division is to kind of promote a process that is convenient, cost effective, quicker, and that's always been the goal. And so the ADR program has gone through a couple of evolutions. When there was the foreclosure crisis, it was used in a different way. Now we see more and more homeowners using it, and to make it more effective, I believe there was a couple of bills previously, but really for us, it's going back to how the ADR process originally started. And the consensus is to move it more towards an arbitration process. And Sonia has a kind of comparison between mediation and arbitration. I think the trick here is always the cost. The arbitration process costs a little more, but we're committed to figuring out a way to fund some of that or subsidize it like we do the mediation program. And so this discussion is essentially, the goal of this is to give the task force an idea. Most of you folks already know about the program and kind of some of the issues. This is to give you a comparison, and then we also have some invited guests from the courts to kind of give us an overview of their ADR process so we can get some best practices. And ultimately, our goal is to come back at the next meeting with some suggested language that we believe would statutorily we could change that would move us into this arbitration process, which I believe is a really good way to continue the ADR program. So with that said, I'll turn it over to Crystal to kind of quickly make introductions, and then we'll go into the presentation.
Thank you, Administrator Chandra. This is Senior Deputy Attorney Crystal Keegan for the division. We are very fortunate to have Commissioners Aaron Lee Truman and Adam Gantz. They are the ADR Discovery Commissioners for the 8th Judicial District Court to provide us with an overview of their program and maybe as a potential model to streamline the division's ADR program. And so I'll turn it over to Commissioner Truman, and the ADR in a nutshell PowerPoint presentation that she provided is in the materials, and unless Commissioner Truman wants them up on the screen, we can facilitate that. Otherwise, I want to assure you that that is available to all the members in the public.
Thank you. I am Commissioner Aaron Truman. I don't know if Commissioner Gans has been able to join us. He had a conflict and he was going to try to join, and I apologize. I had difficulty logging in, but I'm here now. So first of all, I just want to just introduce our department. I am one of the 2 ADR commissioners, Alternative Dispute Resolution Commissioners for the 8th Judicial District Court in Clark County. And we administer the court-mandated ADR arbitration program, the mediation program, which is purely an elective program, and then the short trial program and the Nevada foreclosure mediation program. I've been asked to talk about 2 of them, the mandatory arbitration program and the mediation program, and kind of discuss the benefits of those. And so that's what I have prepared PowerPoint slides, and those have been provided to you. I want to kind of keep it at a 30,000 level, a high level, because of the time constraints, but I'm welcome to, I'm happy to come back and anytime and answer more questions. So I won't share my screen, I'll just go through them, but ADR in a nutshell, beginning first with the court annexed arbitration program. What is mandatory arbitration? In Nevada, well, first of all, mandatory arbitration is a procedure where it's required by statute in our state and rule, and certain cases are diverted from the normal litigation track into a non-binding arbitration program before trial. And a neutral third party, the arbitrator, considers all the facts and arguments and evidence presented by the parties, takes live testimony and sometimes testimony by way of affidavits, and renders a decision. It is an informal, but it is an adversarial process. Each side gets to present their version of what occurred, and then an award is issued, and it is non-binding. Either side may request a trial de novo, can say, we're not happy with this, we want a trial. And so according to the rules, and those are the Nevada arbitration rules, those can be found on the 8th Judicial District Court website. They can also be found in the state websites as well, but in the 8th Judicial District Court websites, all the forms and rules are provided for you there if you're interested in looking at those. But according to the arbitration rules, the purpose of the program is to provide a simplified procedure for obtaining prompt and equitable resolution of simple matters, of certain civil matters. And currently that is for any case in Nevada, with some exceptions that I'll go through, where the amount in controversy is under $100,000. So if any party is not satisfied with the decision of the arbitrator, they have the right to request a trial de novo. And then that automatically goes into our Nevada short trial program. Or if they don't want to go into the short trial program, which has other rules and caps on how much you can receive, they can do what's called a demand out of the short trial program and proceed into a normal trial. But let's talk about the cases that are subject to the arbitration program. Any case that's filed in, and I'm going to talk about Clark County, but to my knowledge, the only two counties in the state that use this are Washoe and Clark. And Washoe's program is a little bit different than ours. But in Clark County, civil cases that are commenced or that begin in the district court that are filed, they can be removed for several reasons. They can be removed for automatic exemptions, and those would include anything that's a class action, an action in equity, actions concerning title to real estate, actions seeking declaratory relief or extraordinary relief, appeals from courts of limited jurisdiction, judicial review of administrative decisions, prior written agreements to arbitrate the case, medical and dental malpractice cases, any action where one of the parties is incarcerated, any action where it's an insurance bad faith case and the parties are claiming punitive damages, cases involving sexual assault or sexual battery, or product liability cases. Those are cases where they can be automatically exempted if pled properly in the complaint. Then there are permissive removals from the program, and those would be any where there's good cause for removal, which would involve public policy, cases that have any other anomaly that would justify good cause, or any case where the value per plaintiff is $100,000 or more. And that limit was just instituted by a legislative change last summer for any case filed after January 1st of this year. So all cases filed before January 1st of 2026 that are those cases are only subject to a $50,000 cap. So you would have to file they're permissive for cases under $50,000, but the new limit is 100. So we, in our arbitration in the ADR office, we review every civil contested case that's filed in the 8th Judicial District Court. Every case that's filed flows through our office, and we look at every case that's filed. The ADR commissioner, or myself or Commissioner Gann, we review approximately 8,000 files per year to determine whether or not a case should be directed to arbitration or if it should be removed from the program. And approximately half of those cases, or 4,000, remain in the arbitration program, while the remainder are exempted either automatically or by filing a request for exemption from arbitration that the commissioner reviews. So the ADR commissioner is charged with the responsibility of resolving any problems that arise from the arbitration proceedings, and we serve at the pleasure of the district court judges. Really, our goal and function is to keep all of these smaller cases off the judge's docket, to help them resolve quickly and efficiently and fairly without the need to take up judicial resources of the district court judges. So at the direction of the ADR commissioner, the office that I administer, the ADR office processes and randomly assigns arbitrators from the panel of over 600 approved arbitrators to more than 4,000 cases per year. And that's in addition to monitoring all arbitration proceedings to conclusion, whether it's by an award, by the settlement, or the return to the district court docket. So we monitor all cases as they proceed through the arbitration program and make sure that they are being handled within the time frames that are required by the rules, so that nothing languishes and takes more time. Generally, the arbitration program, the arbitration hearing is to be held and awards issued within 6 months of the arbitration program. I'm sorry, within 6 months of the arbitrator being assigned. For certain, as a result of requests for certain reasons, those can be extended, but by no means can they be extended beyond a year. And that's what the legislature has put in place, and the Supreme Court of Nevada has adopted for the mandatory arbitration program rules. So what does the ADR office do? We determine which cases should be placed into the court annexed arbitration program. We assign the arbitrators that will handle those cases, and those arbitrators have to request that they be allowed to serve as arbitrators from the Supreme Court. They have to be trained, which our office does, and they have to be approved by the state bar to be arbitrators in the program. We resolve challenges to the arbitrator's actions. If one party challenges what an arbitrator has done, then as the arbitration commissioner, we resolve those challenges and make a decision. And if there's any objection to the bills for fees and costs of the arbitrator, the arbitration commissioner also resolves those. We monitor the cases for compliance with the timelines outlined in the rules, and if the timelines are not being followed, we set the case for hearing, or we send notifications to the arbitrator that they need to do certain actions within a certain time. So what powers and responsibilities does an arbitrator have? An arbitrator administers oaths and affirmations to witnesses. They notify all parties of when the hearings will be set. They accept evidence. They relax all applicable rules of evidence and procedures to accomplish a speedy and economical resolution of the case. But that's not to say that the party's right to a full and fair hearing is ever sacrificed. That is really essentially, they want to do things speedy and economically, but without sacrificing a party's right to a full and fair hearing on the merits. So the operative word in arbitration is the rules of evidence are relaxed, but they're not ignored. It's not a kangaroo court. Arbitrators have the basic responsibility to provide each of the parties a meaningful opportunity to be heard in each case. And so the arbitrator, to do that, has the discretion to determine what, if any, discovery will be allowed. And that is at the discretion of the arbitrator. If one party or the other is dissatisfied and thinks that the arbitrator has exceeded their bounds, they can file a challenge to an arbitration commissioner to review it. The arbitrator has the complete discretion over the conduct of the final arbitration hearing and what evidence will be allowed or accepted. And the arbitrator determines all issues that are raised in the pleadings that are on file with the court, including comparative negligence, damages, and costs. If a case regarding equitable relief is left in the arbitration program, they also can decide what equitable relief, if any, is warranted. That differs from the mediation program. The court annexed arbitration program is automatic. It is mandatory. You have to go to arbitration if you enter the program. While in the program, the parties have the right to elect or to stipulate or agree to enter the court annexed mediation program. And if that occurs, a case is assigned to the lawsuit is assigned to a mediator by the ADR office, and the cases are to be mediated within 60 days. As I said earlier, if either side is dissatisfied with an arbitration decision after the time in the arbitration program, they can appeal the matter to a short trial program or ultimately demand out of the short trial program and go into the regular trial program. If after 60 days in the mediation program, the case isn't resolved, if there's no resolution, then the matter automatically goes into the short trial program. And then once in the short trial program, within the time period prescribed, if the parties aren't satisfied with the decision, they can demand out and go into the short trial into the regular litigation program from the short trial program. They can demand that they be released from the short trial program and go into the regular trial program. But everything that happens in mediation remains confidential. It's not discussed at the trial. At a trial in the short trial program or in a regular trial, what happens in arbitration, the decision of the arbitrator can be introduced to the jury. So that is one difference between the mediation program and the arbitration program. The arbitration decision can be read to the jury. So that's the overview. I'm happy to answer any questions. I know time is short, but I'm willing to answer any questions. I'm willing to come back and address other things that maybe I've raised that you have more questions about at any time. So I'll turn the time over for questions.
Commissioner Truman, thank you. That was great. I see we have a question from Michael. Mr. Buckley, go ahead.
Thank you, Aaron. The question I had is, wouldn't most issues CC&Rs involve the interpretation of the CC&Rs or something? So it seems like declaratory relief would be the most relief that you'd always want. So how would you do that?
Well, in our program, that would be an automatic exemption if that's what's pled. If the parties agree to arbitration, the arbitrator can make the decision on the declaratory relief. The arbitrator has the ability to do that, but if the parties want a judge to do it, they just need to file a demand out. So our rules may not be an absolute fit, but there's certainly rules that could assist the parties that you all are overseeing in resolving the disputes in the same manner. But perhaps some of our rules wouldn't be a complete fit for your program.
Thank you.
Do we have any other questions for the commissioner?
Yes, I have a question. Could you say a bit more about how arbitrators are approved? Because I think that's an issue. Could you say a bit more about how arbitrators are approved? What qualifications they need to bring to become an arbitrator within this program?
Okay, well, they first of all have to have 8 years litigation experience or other experience as a member of the bar. Non-attorney arbitrators can be approved if they have similar experience. They then have to make an application to the State Bar of Nevada, and this is all contained within the rules. They are vetted. They make the application process. Then, before they can be assigned to be an arbitrator through our office, they have to attend a training session, and it's generally it's a 4 hours. They're required to attend that every other year. So they have to, re-up, and they have to do the training where we go through all the rules, all their requirements, all the timeframes, all the issues that we see over the past 2 years. We raise any issues we've seen. They also, through our office, anything that we're seeing on a continual basis, we'll send out letters in the interim trying to advise or train them of any rule changes or any issues that are repeated that are challenges to us. For example, if people aren't sending itemized bills, if we see that tending to be an issue, we'll send out letters reminding everyone that they're required to do that. If we're seeing them sending out arbitration awards late, we'll send out reminders of what the timeframes are, and we hold them to that standard. If things are not followed, we have a very complex system where we're really lucky in the 8th Judicial District Court. We have a program that will tell us when things are not being done timely, and we can set them for hearing or send them what we call an ADR action required, telling the arbitrators that they have to take a certain action to get something done within a certain time period and report back to us.
And one more follow-up question. This is Donna Zanetti. What is the hourly rate for the arbitrators?
The what? I'm sorry. The hourly rate? It's $150. It's $150 per hour, limited to a total of $1,500 per case.
Thank you.
Thank you. Any other questions for the commissioner? Yes, go ahead. David?
I would like to ask, how effective is this program in your opinion?
Well, we've been doing, the reason we were able to raise the limit to $100,000 is we are having we're seeing that the resolution is approximately 90% either through before the trial de novo was requested. 90% of cases have been resolving through the arbitration program.
Very good. Thank you.
Which we think is excellent. I mean, we're happy to see it be so successful.
Thank you.
Any other questions? Bill?
I have to correct myself. There was just an increase in the arbitrator's fees. It's $150 per hour for a maximum of $2,000, not $1,500. It has been raised.
Hi, Commissioner Truman. Phil Sue. I'm with the Attorney General's office. I used to be a litigator in private practice and have some understanding of the system probably 2 or 3 iterations ago of how mandatory arbitrations work. I know that there's no shortage of arbitrators that would want to participate because that literally is part of their workflow is the mandatory arbitration program. I believe that there may be different challenges in terms of retaining arbitrators for this program, especially at the rates that the program that your program is able to compensate for. Do you have any thoughts as to how we could approach our program as far as compensation or recruitment of arbitrators?
Well, in our program, the parties pay the arbitrators. The court doesn't pay them. The parties are required to pay the arbitrators, and they must pay the bill equally. It's not the prevailing party has to pay all of it or gets a free pass. Both parties under the rules are required to pay equally. The only time that doesn't occur is if one of the parties is deemed indigent by the district court. And that has to be an application process where they're deemed to be indigent under the statutes. And then the arbitrator can recover nothing. They can't charge either side. To be fair and neutral, they can't charge either side because it may look unfair that they're getting paid by the non-indigent party. They may tend to favor that party. And so we then offer, under the rules, they can claim that as pro bono time to the state bar. But I don't know what the fees for your program are. I don't know who's responsible for paying it, but the way it works in our system is that the parties are responsible. I used to practice in Arizona as well many moons ago, almost 30 years ago. And in Arizona, the court pays for it, and it's like $100 total for the entire arbitration. But the arbitrators, it's not elective. If you are a member of the bar practicing in the state, you are required to serve as an arbitrator. That's not the case here. And we have found that by having arbitrators who have to apply and want to become an arbitrator, they're more interested and I think do a better job than if they were just appointed and had no choice in the matter.
Great. And a follow-up question to something you had mentioned earlier on. You mentioned that those with equivalent experience that were not attorneys could also apply. Could you just explain a little bit what kind of experience would those types of applicants require? For everybody's interest.
I'm not completely clear on what's required by the state bar to allow that. I do know that in many cases, they are attorneys who've been licensed in other jurisdictions or people who have served in other capacities, perhaps with labor unions or other persons as arbitrators and have had some kind of training in the field and have worked in the field before. It's just, you just can't apply and have no experience and be able to become an arbitrator in the program.
Understood. Thank you.
You're welcome. Any other questions I can answer?
Crystal, go ahead.
Thank you, Director Dr. Sanchez. This is Senior Deputy Attorney Crystal Keegan. Thank you so much, Commissioner Truman, for your presentation. It was very insightful. I just had a follow-up question on your court annexed mediation program, cases mediated within 60 days. And so I was wondering, is that realistic? Are you meeting those? And if so, the timeframes that you have set up within your rules and program as far as meeting that 60-day mediation, if you could share that with the group.
To be perfectly candid, we don't have a lot of parties who elect to or agree to go into the mediation program, but when they do, they meet the 60 days. The reason for that is they typically are doing it before any discovery. So they're just going straight to mediation with the evidence that they already have. And then if they're not satisfied with what the mediator is able to accomplish, if they can't resolve it, then they go into the short trial program where they then do their discovery. So yes, it's really we both go with what we have. We don't do depositions or interrogatories, requests for production of documents, subpoenas. None of that happens. They just really go to the mediation, and if it can't be resolved, then it goes to arbitration. But sadly, that's one of the frustrations in our office, is that more parties aren't willing to agree to go to mediation. They just want to go to an arbitration and get a decision, and then if they're not happy with it, appeal it, or it becomes binding.
Any other questions for Commissioner Truman? All right, seeing none. Commissioner, thank you for your time today. Really appreciate the presentation.
Of course.
Take care.
Thank you.
Moving on to agenda item 5 for discussion of possible action, and turning it again over to Administrator Chandra.
Thank you, Director Sanchez. So on agenda item 5, we've got a couple of items, so we've kind of grouped them together. So essentially, the one item that we have kind of scheduled to talk about, and this is the one that is I believe an important one to discuss. When we put this agenda item on there, our expectation is not to come to some kind of a immediate resolution or some kind of a consensus, but to just discuss it as a task force and get everyone's viewpoints, because we see it in one perspective and we want to get everyone's perspective on this matter. And then we'll just kind of progress this along. Not really sure where it's going to get us, but I think it was an important one to talk through. You folks have 2 documents with this. One is a brief kind of a summary overview, and then also an advisory opinion from the division. What I want to do is I want to turn this over to Crystal, who can kind of frame this quickly, and then really we want to talk through this one and get some feedback from the task force members. Hopefully everyone's looked at this. If you haven't, we can discuss it and then bring it back up at the next meeting also to continue the discussion. But we wanted to start this discussion on this item. I think it's pretty relevant and it's important for us. So go ahead, Crystal. Thank you.
Thank you, Administrator Chandra. So Senior Deputy Attorney Crystal Keegan for the division. So what we're looking for here is just help from the task force members on this topic, because we do get a lot of questions asking about guidance on NRS 116.3183 about what constitutes a formal board meeting that would be subject to the notice, agenda, and minutes requirements. And so what we have presented here lays out the statutory landscape under Nevada law. And you can see there are different mechanisms for action without a formal meeting, depending on the entity type and status. And because many HOAs are organized as nonprofit corporations, we pointed out NRS 82.271 as relevant, unless, of course, it's superseded by some specific provisions of NRS 116 or the association's governing documents. We also referenced the division's advisory opinion 11-1, primarily to just point out that some interpretive groundwork exists, but because advisory opinions are limited to an interpretive function, we can't expand upon or create obligations upon boards beyond what is expressly provided in written law. And that's plainly under NRS 116.623. So since NRS 116 does not define meeting, we wanted to bring this to the task force to determine if statutory clarification is needed and what that might look like. And before we have this discussion and turn it over to the group, the Ombudsman, Mrs. Merriweather, she can provide more background on what frequently comes to her office on this topic.
Thank you, Crystal. Ombudsman Merriweather. What does happen that we get notified through the office is that boards are conducting business outside of a meeting, that the unit owners lose the ability to have access to the boards when they're making these decisions and hearing the information that results in either, say, a vendor that's being hired or something that the board now or the community now is obligated to. And so this has presented itself to be a concern for the unit owners in these associations that, you know, sometimes they file a complaint with our office, sometimes it's just a telephone call, but we do recognize that there needs to be some type of language so that boards are aware of whether their action outside of a meeting now crosses over and contradicts with 31083 as far as the requirements for notices and the ability of the unit owners to participate in these discussions.
Do you have any comments? Donna, go ahead.
Donna Zanetti. So it seems to me that while this is being phrased in terms of what is a meeting, the subtext is, can boards engage in actions outside of meetings as allowed under NRS 82? And can boards engage in workshops? And these are always perennial issues that seem to come up around board meetings. I think that both are important to preserve if we're going to have any definition of what a meeting is, although that seems pretty straightforward to me. But, you know, we always try to counsel boards, don't use these processes as a substitute for open meetings, because it seems clear to me, at least, that NRS 116 really does contemplate that boards are going to make their decisions in open meetings after notice and agendas. And there's even a process for emergency meetings. But the statutory minimum number of meetings is 4. So you have lots of associations that contract for 4 meetings a year, and each additional meeting costs that association more money that they have not budgeted for. So we need to balance the real world costs of calling a meeting every time you need to make a decision against the, you know, what is allowed under corporate law, the ability to take some action outside of a meeting, and the very real necessity of boards being able to meet in a workshop setting without making decisions and gain information that, frankly, on areas like asphalt repairs, where it would just take too long to do at a board meeting. Is also typically board meetings are 2 hours or less. And if you're going to exceed that amount of time, that costs associations additional money as well. So in my mind, we need to consider these practical effects of any regulatory or legislative changes it's going to have on these associations and their budgets.
Jason, did you want to weigh in?
Absolutely. Thank you so much, sir. No one said the magic word, and I'm going to go ahead and say it because I think that when the Ombudsman's office is receiving complaint or receiving concerns from homeowners out there, what they're really talking about is not so much a meeting as transparency. Transparency that's the whole drive of agendizing items, doing the votes in an open meeting, all that good stuff, is to provide that transparency. Now, we can define or we can work towards a definition of meeting, et cetera, and so on. But at the end of the day, the governing documents, the original bylaws, and to show that I've been paying attention in my classes all these years, the original document still stands. It hasn't been altered. It hasn't been updated. It hasn't been amended. So therefore, it still has strength. And if those bylaws allow for action outside of a meeting, which just about every set of bylaws that I've come across do in one way, shape, or form or another, no definition is going to really, I don't think it's going to help the problem. What I think the solution to this is, more so than defining meeting, is perhaps requiring an after action. If you take an action in pursuit or in compliance with your bylaws, then you shall, using the operative word there, place an item on your next regular meeting agenda to ratify, formalize, whatever verb you want to use, the action that was taken out of the board outside of a meeting in compliance with the bylaws and the allowed powers given in that document. That, I think, is the overshadowing issue to all of this, is the transparency factor. That's where we lose our homeowners. And as a practitioner, and coming from that perspective, that's what we fight against. Just to Donna's point a moment ago, we try to use this as sparingly as possible because we realize that we are supposed to be so transparent with everybody, with the members of the community, with the state, et cetera, and so on. So we use it as sparingly as we can. Now, does it happen? 100%. Absolutely. I think every community manager out there would agree. It happens. But usually our professional advice is, okay, do we actually need to do it this way, or is there a meeting coming up, and does it require immediate action? A lot of times practitioners will go, okay, we're going to use this power given to us in the bylaws, but we're going to balance that against what's an emergency. And so we go to the emergency section and look through the definition of emergency. And if it requires the immediate attention of the board, then okay, the board, obviously within its power, can take that action in accordance with the bylaws. But again, I think the solution to the frustration that's being experienced by the division is simply some sort of mechanism that requires the board / management, whomever, to report and announce any action that was taken outside of a meeting back to the membership, to provide that knowledge, to provide that transparency. Thank you very much. I know that was long-winded, but transparency is key.
Thanks, Jason. Appreciate that. Michael? Oh, you're muted. Yep.
Thank you. I think Donna and Jason, both made good points, and you know, from the lawyer point of view, it's simply corporations typically do things by written consent or signed something without a meeting. And but I agree with both of what you were saying. It's not what is a meeting, but what can you do with by written consent as any corporation under, as Jason says, under their bylaws or under the corporate laws, you can always do things without a meeting by written consent. So perhaps the solution is to define what, in 116, the kinds of actions that can be taken without a meeting.
Thank you, Michael. Mark?
Hi, I'm Mark Leon, bringing a board member perspective. Because boards meet infrequently, there are occasions where time-sensitive decisions have to be made outside of a scheduled meeting. In my association, these actions, usually by email, are formally explained and ratified at the next regular meeting. Our bylaws specify that decisions made outside of a meeting have to be unanimous. With regard to meetings versus workshops, I've had experience on boards with the philosophy of hashing out every item on the agenda in the presence of the homeowners, and the alternative philosophy of holding informal workshops a week or so prior to the regular board meeting to hash out the details of agenda items, but leaving the actual decisions for the formal meeting. The former philosophy often results in long, chaotic meetings where decisions are often delayed until the next meeting in order to get answers to questions brought up during the discussion. This format also lends itself to unsolicited audience advice in cases where the board members are struggling back and forth on a particular topic. It further frustrates those homeowners who wish to offer discussion during the second homeowner open forum, but are forced to wait until the end of the meeting to be heard. In the latter philosophy, agenda items are discussed in advance at the workshop, so when questions arise, the management staff can research the answers and have them ready for the formal meeting. In that subsequent formal meeting, the decision process goes smoother because the board is already familiar with the agenda. In addition, the display of competence by the board on the various topics at hand convey a reassurance to the homeowners and attendants that the association is being well run. These meetings are often faster, so homeowners with second open forum discussion get heard quickly. The public comments bring up questions of transparency and homeowner participation. Regarding transparency, while it is true that the meeting records are available to homeowners at a time following meetings, we don't make copies of the board book available for homeowners prior to or during the meetings. The reason is that it is not a homeowner meeting. It is a meeting of the executive board, and the homeowners are only observers, with the exception of the first and second homeowner forums. Regarding homeowner participations, there are situations where the board welcomes homeowner input, and this is effectively done by formally establishing committees. In my association, we have several committees where homeowners are privy to detailed information and discuss and vote on recommendations to bring to the executive board. Thanks.
Thank you, Mark. Assemblywoman Kasama?
Thank you, Chair. Thank you, Donna, for always reminding us of the practicality of the cost for these things. And Jason, your comments were one of mine where you basically ratified information that, or action that has already been taken. I would also like to put forth that perhaps we could, and I know legislatively, we don't like dollar amounts in our regulation, but is there a consideration for a dollar amount other than an emergency that would require that the item be addressed in the board meeting? So if you're doing routine repairs and the landscaper has to have more for trimming 20 palm trees or whatever it might be, is there a limit we could put in that the board must go before the board must go before the homeowners for a vote for basically restricting it to larger contracts? So I'm thinking perhaps a dollar amount might give everybody some guidance as to what the board can just execute to keep things moving smoothly. Just a consideration. And I would also ask, what would be the next step here? Would we ask the staff to draft perhaps some definitions of meetings, taking into account some of these comments that we could review for the next one? Thank you.
Thank you. And then David, I see you have your hand up.
Yes. As far as a dollar amount, could it also be a percentage of your budget rather than a strict 25,000, a certain percentage of the budget? We recently had a situation where we wanted to approve $40,000 in landscaping costs, and the board didn't want to do this by email, so we had a special meeting just to bring this before the board because, or the community, because of our fiduciary duty. We thought they needed to know about this. That's all I have. Thank you.
Thank you. Michael?
Just one comment. I think what David just said, rather than a dollar amount, but tying into a percentage of budget or something like that. And you think of like in a construction loan, you have all these categories and you have budget amounts, and the owner can move things around as long as you're staying within the budget, and you're you don't need to go back to the bank for approval. And I would also comment on what Jason talking about ratifying. I think that I don't think you want to go that you have to ratify it, because then what you did still wasn't final action. So I think you just want to disclose it. I think makes perfect sense to me. Thank you.
Thank you. Donna?
I think that while you might consider a percentage of budget, it might be helpful, for the board members and Jason and I to give you an idea of the kinds of things that come up on an emergency basis that might require this action by written consent. So an example that I would offer is renewal of insurance. we all wish that property insurance and the other insurance policies would, provide their renewal quotes even a month before the current policy is going to terminate. But the reality is, in this marketplace, we have clients who are getting their renewal quotes 14 days, 10 days before their current policy will terminate. And in some cases, these quotes are for millions of dollars. I would think that items like insurance renewals, regardless of the percentage of your budget it contemplates, are something that needs to be addressed in a timely manner and may well qualify for action by written consent, because the consequences of failing to fulfill this responsibility under state law and the governing documents is so dire that regardless of a percentage of budget, it really needs to be done in time to ensure insurance, for example. So that would be my example of, and maybe Jason and the board members have others.
Any other
I'll,
comments? Go ahead, Jason.
I'll jump. Yeah, another example I realize would be a vendor unexpectedly quitting, or just again an immediate need of the community for a service or by a vendor. And I don't have necessarily 3 days to notice a special meeting or an emergency meeting. I don't have 10 days to notice a regular. I've got to take action to ensure the preservation of the physical asset, and they require action. And using the mechanism given in the bylaws, whether it's unanimous or majority, boards will do that from time to time. But yeah, there are absolutely things that come across day to day that could theoretically qualify. And I think it's up to the professional in the field to help the board understand what the difference is, and can it wait, or is action absolutely needed.
Thank you, Mark.
Well, there can also be an instance where an action has already been discussed, but a board member or two wants to delay just for reasons of eyeballing the situation themselves. Like, for example, a real world example is we approved or discussed a massive landscaping project that would cost hundreds of thousands of dollars. Went over it in the board meeting, but at least one of the board members felt that they really wanted to see the project on the ground before making the final decision. And in that case, the decision was important to make quickly because there's a certain time frame where planting makes sense. And if you delay it to the next meeting, then you have a problem with the planting and it's too hot. And so there's been instances where we've said, okay, let's go ahead and pen this item and then approve by email, and then ratified that decision in the next meeting, so that the board member has a chance to look at the situation and make their decision then. So that's happened in the past.
Okay, do we have any other comments from task force members? Crystal or Sharath, did you want to weigh in on next steps potentially, or should we bring this back for conversation in the next with some examples or suggestions in the next meeting?
Thank you, Director Sanchez. So I think I prefaced this. This was an important topic that we wanted to discuss, but again, like I said before, the idea was to introduce this, get some discussion going around it, because it's a hard decision, and I get everyone. The transparency issue is key. The practicality of actually running an association and managing the day-to-day, that's critical to the dollar amount, the percentages, those also factor in, but also, there's some time-sensitive things. So I think that I think there are a couple of things that kind of came out of this, at least for me, is Michael's suggestion about written consent. So our thought is, is there a consensus to actually put some language in 116 versus rely on 82 and all the other sources to kind of develop, or rely on the CCNRs that are already existing to kind of use that as a backdrop to make those decisions? I think that's really the big question. So for us, whether it's adding exemptions to 116 or whether qualifying what matters have to be in a board meeting or exemptions, I mean, that's kind of where the thought process is. So what we'll do is we'll go back, we'll look at all of this, and then we'll put together maybe a bullet point of priorities, and kind of weigh them, because really ultimately the decision that should come out of this task force is, at least, is there any appetite to actually look at 116 and make some progressive changes there to address some of these concerns? Or do we rely on, the existing framework, and then maybe there's guidance from the division, or maybe there's something else? I'm not really sure, but I think it was important enough for us to kind of bring it up. And clearly there's a lot of opinions and thoughts around this. So that's really my takeaway from this.
Thank you. Crystal, do you have anything you wanted to add to that?
This is Senior Deputy Attorney Crystal Keegan. Thank you, Director Dr. Sanchez, for the opportunity to add to that. I would just say what we could do, if the director, if you wish, is we could do something similar to what we did under agenda items under number 5, sections 2, 3, and 4. And so whatever the consensus is that came out of our discussion here about board action without a meeting, we can compile a document and have it ready for the next CIC task force meeting.
Yeah, I would recommend that we proceed that way if the task force agrees.
Okay.
Seeing some nodding heads, so I think that'll work. Well, I appreciate the back and forth and the input on that. Are there any other final points on agenda item 5?
This is Senior Deputy Attorney. Oh, pardon me. Go ahead.
No, go ahead. Sorry, Crystal. I didn't mean to interrupt.
Okay, this is Senior Deputy Attorney Crystal Keegan. So under agenda items number 5, sections 2, 3, and 4, and I know we're running short on time. So if the director, if I may, we provided this because this is the consensus that came out of the last meeting, and I can briefly go over each statute we looked at last time, and then I can just defer to you on how you want to handle that, if that's okay.
Yes, I want to check with our task force members. How's everybody doing on time? Thumbs up. Good. Okay. You're good, Crystal. Go forward.
Okay, very good. Thank you very much. So item 5.2, we looked at NRS 116.3115, section 9. Specifically, we looked at the need to define capital improvements. So how we've laid this out is under the summary of recommendations headline there, we've listed out in the bullet points the comments from the group, which appeared to agree a clear working definition was necessary. There was discussion identifying what criteria would trigger capital improvement status. There was discussion about clarifying project classifications and determining really the appropriate pathway for guidance. So would this go through regulation or an advisory opinion? And then under suggested language, some members offered a definition that emphasized additions of new or substantially different components to common elements. And then the group identified what was not a capital improvement, like repairs and maintenance. And lastly, a cost threshold backstop was suggested. So that's all provided there. On item 5.3, NRS 116.31087. Okay, so that one was the one we looked at, clarifying the process for placing owner complaints on the board's agenda. So same thing here, under the summary of recommendations section, the group tried to strike a balance between legal and operational considerations. There was discussion identifying matters appropriate for executive session, possibly a need for clarifying evidentiary expectations for the written complaints. And then there was comments about whether this statutory mechanism is even necessary, or is the existing owner comment period good enough? So the suggested language focuses on cleanup of clunky language, and there was additional discussion regarding protections for both owners and boards, and that included clarifying language that boards aren't required to hold public dialogue on matters that are otherwise executive session matters, which are legally spelled out in NRS 116.31085. And there was a suggestion to require the board to provide the owner with a written response within a specific time frame so that at the end of the day, the owner has something in hand, and if they choose to pursue the matter, they can go to the ombudsman for guidance on whatever the appropriate pathway is, whether that's either through the complaint process for NRS 116 violations or the ADR for governing document issues. And then the last item, item 5.4, NRS 116.31031, we looked at defining what constitutes reasonable time when temporarily restricting an owner's voting rights or their access to common elements for violations. And the recommendations from the group included adopting objective criteria applied consistently. There was discussion about what would be practical time limits, and then we took a look at rulemaking as an option for establishing clear standards. The group also explored the appropriate use and proportionality of sanctions. And again, there was discussion about if this change was even necessary, since governing documents often provide for specific suspension periods. And so that's my recap, and I will respectfully defer back to the director for a recommendation on how to proceed. Just to note that if these collective recommendations are going to be committed to in a final report, I would say that's considered action. And so to be safe, there's probably should be a formal vote on it, but Senior Deputy Attorney General Phil Sue can be consulted on that as well. Thank you.
Phil Sue, for the record, I agree.
Thank you. So with that recommendation, is there any comments or questions on what Crystal has just reviewed? And anything that in your reading of the documents that anybody may have any clarification needs on? Go ahead, Mark.
Michael Buckley.
Oh,
sorry. Sorry, Mark. Go ahead.
Yeah, in the previous task force meeting, when we were talking about the definition of capital improvement, I know that Mr. Horn had an issue with the last sentence on the definition, and I'm fine with dropping that last sentence.
All right, Michael, would you like to weigh in?
The only thing I would say is that, and we do at the real property section, we come up with a lot of proposed legislation and talk about it, and then we actually put it in, to a document that you can look at it like it's, this is what it's going to look like. And then I think you have another opportunity to think about it again and read it again. So I think, going forward makes sense to me, and putting this in particular language so we can see what it looks like would be a logical step.
Okay. I think we have
second that. I'll consider that a motion and second
it. All right. Well, we have a couple more comments to get through, and then we'll take action on that. How's that sound? I think we had Donna next.
Okay, on 31087, I guess this is just in the discussion at the bottom of that page where item 3 says if a complaint remains unresolved after a board's response, then the association has to inform the owner of the right to seek next steps from the ombudsman's office. I guess my suggestion was, let's make this simple. How about rolling it all into the response so that we don't have to we don't have to take another step and issue another letter. It'll just be a boilerplate statement that gets added to every response. And on 31031, I see that voting on matters related to the common interest community was lined out. Was that a deliberate change? Because I don't recall that we discussed eliminating the sanction of suspending your voting privileges.
This is Attorney Buckley.
And that was something I remember bringing up, that it seemed like an overly didn't really fit didn't fit the crime that you can't vote on stuff. You should not be able to use the common elements, but voting on stuff didn't seem to make sense as a proper appropriate punishment.
So this is Senior Deputy, oh, pardon me.
Yeah, I would disagree. I think that while it is not motivational to many members, it can be motivational to some. And particularly if we're talking about people who are delinquent in assessments, you pay your assessments, you comply with the governing documents in order to enjoy the privileges of membership, which are essentially use of the common elements and the ability to vote. So I really would not be in favor of eliminating the suspension of voting privilege, eliminating voting as a possible sanction.
Go ahead, Michael.
Just to respond, and I guess, Donna, what I would say is that, looking into the lead-in language, it says it violates any provision of the governing documents. So certainly violating any provision of the governing documents shouldn't be a wholesale right to say you can't vote on anything. That seems to me, if there's specific things, like if you're not paying your assessments, I get that maybe, but if you have a landscape violation or you made too much noise at the pool or something like that, it seems it should be more tailored.
Have to agree to disagree on that, Michael.
All right, Jason, did you want to weigh in?
Yeah, I would actually second Donna's opinion. I don't like stripping an available remedy away from the board. Generally speaking, NRS 116 has systematically done that effectively over the last 15 to 20 years. So I think if we can prevent the removal of a remedy, that would be lovely. I would love to see that unlined out. I think you could say, though, that it would prevent them from being able to participate in an election cycle if you wanted to encapsulate it to one election cycle. Because at the end of the day, right, the fine generally, or when we're talking about fines, right, it must be commensurate with the severity of the penalty. And in some cases, perhaps the removal of voting rights for a cycle may be appropriate. That would eliminate the need for the 30, 60, 90 theory. Well, that's on common area usage. I apologize. But on the voting, maybe just say it for one cycle or limit it to a cycle at a time. That might be an element to consider. My only other comment was on 3115. In the suggested language section, where it defines capital improvement, second sentence or second line after the comma, distinct from, I would love to see the insertion of existing reserve funded major components. Again, to differentiate, look, you're putting something new in, this is going to be capital, but if it's existing and you're just updating, modifying, renovating, what have you, that's not capital. I would love to see the word existing added to that sentence. And that is all I have.
Thank you, Jason. So just to reiterate, I think we had a request to have amended language, if you will, be presented to the task force, which we can do at our next meeting for a vote. Does the task force all agree? Did I characterize that correctly? Yeah.
Yes.
Okay. Great. Crystal, do you have anything else you wanted to add?
Hi, Director Dr. Sanchez. I do not. Thank you for the opportunity, though, to add if I needed to, but that's all I have today. Thank you.
Okay, great. Thank you. Appreciate the discussion, everybody. I think that may conclude agenda item 5. Were there any other points on that agenda item? Okay, seeing none, moving on to agenda item 6, setting the next meeting and consideration of agenda items for upcoming meeting. Just to reiterate, we will be bringing back those items on agenda item 5 with the recommended changes for consideration during the next meeting. Are there any other topics that the task force members would desire to have considered for our next task force meeting? Go ahead, Michael.
Yes, Michael Buckley. I prepared a list of things that I thought that we might, look into, and I'll circulate the list. Some of the things that came to mind, and going back to what Mike Kosar said today about regulations versus policy or something like that, and the commission. But one of the things, for example, on my list is perhaps have a requirement that the commission report to a legislative committee every year on, what are the big issues, or what are the what are the problems we run into that need fixing, or something like that. Also, we've talked about, mandatory director training. Again, I'll circulate this list. I live in Las Vegas, and I monitor there's a friend of mine, Laura McSwain, who is sort of in battle with the water district about the regulations and so forth of the Southern Nevada Water Authority. And one of the things she just circulated last week, I think, was there's a case in Clark County where some people are saying the water authority can't impose water fines, or I'm not clear exactly what the issue are, but she pointed out that issues being raised for the court include the following. NRS 116.3112, whether any recorded easements, deed restrictions, or covenants affecting common area required approval of at least 80% of owners, whether board actions related to landscape removal were within the scope of the statutory authority, whether board members met their duties of care and loyalty when approving turf removal. So anyway, I'll circulate these. And I have to also mention Deputy Attorney General Keegan's article in the January Nevada Lawyer, and she points out 3 hot topics that certainly we should look into. One was a failure of declarant to transition control back to homeowners, persistent underfunding of reserves, and CAMs held to professional licensing stories. And I guess the other thing too that we haven't really talked about is I certainly would, it's always a big issue in the legal profession is how are people handling their trust funds? And so I'm just wondering if there are any money issues that affect associations that we should be looking at. But again, I'll pass this around.
Thank you, Michael. We'll make sure that we get that list and get it out to the task force as well. Mark, please.
Going back to 5B, does the chair want to consider the approval of the minutes from the last meeting?
Oh, good job. Thank you, Mark. I'm just checking to make sure that the minutes were distributed to the task force. I don't see them in my documentation here from the last meeting. So what we may need to do then is we will bring those minutes back from the first meeting for approval, and we'll have the minutes from this meeting for approval, and we'll do that unless my documentation is just missing the documents.
It was sent to the task force members.
Okay, thank you, Letty. Then that
Yeah,
just
I
seems
see it.
It's
in the packet.
okay. All right, great. Well, but we don't have an agenda item specifically on the agenda for approval.
I move to approve the minutes.
We actually do. This route.
We did.
Yeah.
Then I'm off. Then I'm looking at. Oh, I'm sorry. You guys are on top of it. Your chair is the one with the issue. So I have a run of show that goes through like a cheat sheet, and the run of show is not congruent with the agenda. So I do apologize.
I'll eat that one, Director. That was my bad. I think this route. I think on your run of show, I might have skipped the meeting minutes. My apologies.
Okay. Well, I appreciate that our group is on point here. So I understand there was a motion. If the person that offered the motion can say their name, please. I don't know who had the motion.
It's somebody from behind it to summit. Actually, I'm going to refrain. I'm going to remove that because I wasn't at the meeting.
Okay.
I'm just kind of a get things done person, but maybe somebody else should make the motion.
All right. Oh, Donna, I see you have your hand up.
Yeah, just to toss one more thing in that we might want to discuss as a task force. This was in and among the comments we received for this meeting was the perennial discussion that the way the law and regulations are set up, the division certifies and regulates individual managers and not management companies. And I think that is an issue that deserves another look.
Thank you. Do we have any other, I'm still on agenda item 6 with respect to recommendations for the next meeting. Do we have any other recommendations for the meeting? Okay, seeing none. So what I'd like to do now is we will return to the approval of the minutes. Was there a motion on the table to approve the minutes? Do we have any, or do we have any, before we entertain the motion, is there any changes to the minutes? Edits? Okay, seeing none. Oh, Michael, what do you have?
I was just ready to make the motion.
Oh, go for it.
Move to approve the minutes.
Do we have a second? Okay, David. I think David beat you to it. So David had a second there. All those in favor?
Aye.
All right. Any oppositions? Okay. Anybody abstaining? Okay, great. Thank you. Thank you for that, everybody. And now we will return to let's see, agenda item 7, which is the public comment. Is there any member of the public that would desire to give any public comment now? Please keep your remarks to 3 minutes. State your first and last name. And given that I can't see everybody's little box here, please speak up and then we'll get an order going here. Do we have any public comment? I think we have Mr. Kosar. And please go ahead.
Yeah, thank you very much. Mike Kozar here again. I appreciate the discussion. It was enjoyable listening to much of what was said. I'd like to make one quick comment on ADR, one that I am intimately involved with, which I think most of you are aware, which wasn't discussed, and that's ADR is no longer mandatory according to the Nevada Supreme Court. Per my own case, you'll find that it is waiverable, even though you did not intend to waiver it. I don't think that's what the legislator intended, and I think they got it wrong. And I think that's something that you guys need to tackle before we get too deep in ADR. That's number one. Number two, I agree with Mr. Buckley. My question in the beginning was why many of these discussions, if we had a regulatory system in place like NRS 233B originally envisioned, whereby the commission and the division would go over a lot of these issues, this task force would not be doing what it's doing. So I would ask that the task force take a look at why the system lawmakers have already got it in place to do what you guys have just done today isn't happening on a recurring basis already. And I think that's an important item to talk about. I would also like to point out that as I listen to these discussions, what I keep hearing is what a good faith board would do. And I agree with you. Most of you are, and in fact, all of you that I'm aware of, act in good faith and have good intentions here. But we don't write laws, unfortunately, to cover just what people would normally do. What we write laws to do is cover what abuses might be done, whether intentional, bad faith, unintended, whatever. And so when we start talking about meetings and voting, and we talk about putting something on the agenda, we need to look at it from a perspective of, is the law subject to abuse? And therefore, what changes do we need to make sure are in place so that it's not abused? And I think I would ask you to take a look at that as you go through, particularly the agenda items number 5, all of them. They have been abused. That's why they're there. And did you impart changes that would keep them from being abused going forward? And I think that's what the homeowners are missing here. Not what most, the 90% are doing the right thing. It's that 10%, I think, is why we write laws, unfortunately. So thank you very much, and I look forward to the next meeting.
Thank you, Mr. Kosar. Mr. Bradley?
Hello, Will Bradley. And if I didn't say it before, I am a unpaid special assistant to Senator Carrie Buck for HOA issues. I get all her emails pertaining to HOA issues and respond on behalf of her office. I learned a valuable lesson a long time ago. I'm a retired lieutenant colonel, 4-time combat veteran, Bronze Star winner. And I remember in 1990, I was sitting there in Saudi Arabia over a platoon getting ready to attack Iraq, and soldiers were complaining, and I was getting tired of their complaints. And I talked to my top sergeant and I said, I'm getting tired of these complaints. He said, sir, You should embrace complaints, because when somebody complains to you, that means they care, and that means that they trust you to fix their problem. So when I complain to you, like I'm getting ready to do, I'm glad you're meeting. You give the legislators, including my boss, some cover, because legislators can't stand HOA issues from the fire it brings them from voters. But this task force gives them cover and a well thought out recommendation. So I echo Mr. Kozar. I'm glad you're meeting. I'm in disbelief, however, of some things I've heard on this. Basic training of being a board member, and I've done the board leader training with CAI, is if you have an NRS law that conflicts with your bylaws, the NRS takes precedence. And let's review how NRSs are made. On behalf of the 3 million people in this state, they elect 42 assembly members, like Assembly Member Kasama there. They elect 21 senators, and they elect 1 governor. And it goes through the process, and it becomes NRS law. Not what you want it to say, what it says. And it clearly says that when you have a meeting, even if it's something that came up all of a sudden, you're waived from the 10-day notice and you have an emergency meeting. It's time that boards follow the law. Yes, it's inconvenient. Yes, it costs money, but that's the cost of doing business on behalf of your equal owners of your nonprofit of your corporation that deserve transparency, that deserve to be heard, that deserve to have knowledge and see the process. And that's what gets owners like me, frankly, upset, that boards think they can do what they want to do without consequence. And that's exactly what's happening. I'm also shocked to learn recently from the division that they're no longer going after managers, because they believe managers are acting on behalf of the board's direction. Therefore, the manager is not at fault. But I trust the manager and their license to do the right thing. But mine's not, I'll tell you that. So with that, thank you for meeting. Have a good day.
Thank you. I see, looks like Michelle. Michelle, did you have a comment? You're on mute. Well, Michelle may be having some technical difficulties. Is there anybody else that has public comment? All right.
I got it. I'm here.
Okay.
Sorry,
Perfect
we're
timing.
commonly on Zoom. Community Manager Michelle De Jesus. I used to come to these commission meetings and things of this nature, and I'm glad I'm back. But I wanted to point out a couple of things from the everyday folk that actually do these things. We do have a requirement where when it pertains to the resale packages that somebody signs off that they received them, but that's having had a real estate license and a property manager license. I don't know if that's why I knew that, but that's a common knowledge thing where a realtor is more involved in the transaction between a homeowner and that packet that gets read. We have no interaction other than delivering it, but it is signed off that they received it in the millions of documents. So that discretion needs to go to the real estate side of things, but also too, action outside of a meeting. I know Donna, and I'm so grateful you're here, Donna, because it gives a little bit more of a realistic perspective on things, but actions outside of a meeting are on a ratification situation on every agenda and have been for many years. I thought was required by law, but maybe I'm mistaken and maybe I've had some good people. But a couple of items that I can give you that are a little bit more urgent than insurance and I forget what the other one was, but we deal with sewage backups and we can't wait for a decision for 3 days when that comes to the situation. I've been in a situation where Southern Nevada Water Authority or the sewage district or whatever the situation was at the time is going to shut my property down within 24 hours if I don't address that situation. We also deal with fire alarms and other things of that nature where if of the fire alarms going off for the whole community, we have to deal with an urgent fire watch situation. So I think being a little bit more realistic about whether or not the board can meet on some actions and emergency items does need to be given heavy weight, because as a community manager, we deal with every little aspect of your property, from little to small. It's more than just paperwork and regulations. And if you've got a roof leak, we need to make sure we secure that roof, depending on whether or not it's a condo or our responsibility as a homeowners association. These things are outlined in the governing documents of the community associations, but again, there's always going to be some kind of situation where we need to make a decision and make it fast. Now, as far as people being concerned, I can tell you on average, I might have one person show up to a board meeting once a year. So the concerns about disclosing information or boards meeting, we're grateful for the volunteers that come to our properties and we beg to sign up to come attend these meetings and make some decisions. But I think there needs to be some consideration given to how many people actually are concerned about boards making decisions outside of a meeting versus how many people show up to a board of directors meeting.
Hey,
I've been
Michelle, I'm sorry to cut you off, but you have your 2 minutes.
Yeah.
Thank you.
Okay. Thank you.
Thank you, Michelle. Any other comments on the public comment? All right, just flipping through here to make sure we didn't miss anybody. Great. Appreciate everybody's time today. Moving on to agenda item 8. Thank you again. We will get all the documents out to everyone, and we are adjourned. Thank you. Bye-bye. Have a good day.